afternoon. This is Dr. Olu Asekun here again. Welcome to our live podcast. We are continuing our Coming to Live and Work in the US series. And today we'll be discussing family-based. Can you please help me get into...
Can you help me move?
So, remember to join us. Call your colleagues, family, friends to join us every Wednesday, 12 p.m. Central Standard Time. That is currently 1 p.m. Eastern Time, 10 a.m. Pacific, and 6 p.m. Nigerian time. As I said, today we'll be continuing with our Coming to Live and Work in the United States series, and then we'll be discussing family-based petitions today. So technically there are 5 categories of family-based petitions, and the way immigration law, the United States immigration law, the way it defines family is different from the way English dictionary defines family. So very important to understand. So when we are talking about family, there are 5 categories of family under the United States immigration law. The first category is what is called immediate family. Now, immediate family of a US citizen, the parent, does that interfere with?
Sometimes it does, but it hasn't.
Why don't you just put it on
airplane mode?
airplane mode?
It will still come in. I had one earlier. Oh, but it was through WhatsApp. Huh?
What is it called?
Focus.
Yeah,
Okay.
focus.
There. Personal. It doesn't matter.
Or turn off
Help me check
Wi-Fi.
if is it frozen.
No, it's not.
Okay. Yeah, you go first. Yeah.
Do I need that?
Yes. I mean, they can hear you, but this is gonna be better sound.
Go ahead.
Go ahead.
Has to be plugged in.
Yeah. I mean, once you.
Make sure it's on.
Mm-hmm.
Apology for that. That's what technology does because of the equipment that are not working. So we have to resort to the use of our cell phones for now until the equipment is fixed. It was fixed last week. We tried it, everything worked, but on the day of the podcast, it didn't work again. Here we are again. So apologies. So going back to the subject matter of today, I said there are 5 categories of family-based petition. And I also stated that the way immigration law, the United States immigration law, the way it defines family is different from the way English dictionary defines family. So it is important to not use English interpretation of a family for the purpose of this discussion. So there are 5 categories of family-based petition. The first one is immediate family of a US citizen. Now, what does immediate family mean? Immediate family of a US citizen includes the parents, the spouses, that is, husband or wife, minor children under 21. Again, parents, spouses, and minor children under 21. That is the definition of immediate family for immigration purpose here in the United States. So, your own biological child who is 21 years old is actually not considered your family for immigration purpose. Your grandparents, they are not considered family for immigration purpose. Your married children, unmarried children over 21, they are not considered family for immigration purpose. your siblings, they are not considered immediate family for immigration purpose. So when we are talking of immediate family of a US citizen, for immigration purpose, they are limited to your parents, your wife or your husband, and your children, your unmarried children under 21. That is immediate family. Now, for the purpose of immediate family, there are no restrictions when it comes to immigration filing. So if you fall into this category of a US citizen family member, your US citizen petitioner can actually file a petition on your behalf, and that petition will be treated immediately. It will receive immediate attention just from the word immediate family. So it is given immediate attention. That is why when people come to the US, they want to marry a US citizen, because as soon as they get married to a US citizen, they become immediate family of a US citizen. So that is the first category. Now, for this first category, there are no numerical limits. There is no limit to the number of green cards that can be approved by immigration. The Congress did not set any limit. So if 1 million people fall into this category today and they all submit 1 million petitions, immigration does not have a choice. They will have to process the entire 1 million. There is no limit. There is no limit to the number of approvals that can be done annually for immediate family. Now, having said that, let's go to the next one. The next one is what we call FB1, family-based first category. That is unmarried child of a US citizen who is 21 years old and above. If you are the child of a US citizen and you are already 21 and above, as I stated previously, you do not fall into the category of immediate family. However, you are the first priority when it comes to family, when it comes to extended family. You do not fall into immediate family category, you are into extended family. But even among the extended family, you are the first category of the extended family. So if you have a parent who is a US citizen, but you are already 21, they can still submit a petition for you. However, this category, there is a numerical limit. There is a limit to how many petitions or how many green cards that can be approved annually. And because there is a limit, every time that limit is met, every new application that comes in after that, they go into backlog. And this is why for that category, there may be years of waiting if you do not have immediate visa availability. Now, the next one after that, which is FB2, that is spouses and children, spouses and unmarried children of a permanent resident under 21. So, if you are a green card holder, or if your husband is a green card holder, or your wife is a green card holder, or your parent is a green card holder and you are still under 21, then they can file a petition for you and you can apply for green card under FB2, family-based second category. Now, FB2 is also divided into two. We have A and B. FB2, immediate family of a permanent resident, immediate family of a green card holder. That is one. Then unmarried child of a permanent resident who is over 21. That is two. Now, there is a lot of differences between a US citizen petitioning for someone and a permanent resident petitioning for someone. A permanent resident can only petition for two categories of people. Category 1, immediate family. Assuming that immediate family, it doesn't even matter whether they are in the US or they are outside the US. A permanent resident can petition for immediate family. However, the reason it is important to distinguish between a permanent resident and a US citizen is that even the law differentiates the definition of a family between a permanent resident and a US citizen. When I define family for US citizen just now, I stated the family of a US citizen include parents, spouses, and children under 21, or married children under 21. That is not the same definition for permanent resident. That definition does not apply to green card holder. In the case of a green card holder, that definition changes because it does not include parents. For a permanent resident cannot petition for parents. So, when we are discussing immigration law, there are little differences for every category. So when we define family, when we were talking about a US citizen, we included parents. Now we are talking of the same family, but now we are talking of a permanent resident. It does not include parents. So what that means is that a permanent resident cannot petition for parents. Only a US citizen can petition for parents. A permanent resident cannot petition for parents. A permanent resident can only petition for two categories of people. They can petition for spouses, that is, their husband or their wife. A permanent resident can also petition for unmarried child over 21. That is it. Nothing more. A permanent resident cannot petition for married child. A permanent resident cannot petition for siblings. A permanent resident cannot petition for parents. A permanent resident cannot petition for fiancé. So there is a limit to what permanent residents can do. So under the FB2 category, there is a part permanent resident petitioning for immediate family, and immediate family for this purpose only spouses and minor children, unmarried minor children under 21. Now, what's that? I'm coming back to that. So they can only petition for two categories of people. So a permanent resident can only petition for immediate family, and immediate family for this purpose is only spouses and unmarried child under 21. That is the first category. The second category of people that a permanent resident can petition for are unmarried child over 21. That is it. Those are the only two people that a permanent resident can file a petition for. So if your parent or parent are or is a permanent resident, if you are not married, yes, they can file a petition for you while you remain unmarried. However, a permanent resident cannot petition for a married child. So, very important to understand the limitation and the distinctions. Now, the next category of family-based petition is what is called FB3. That is married child of a US citizen. Again, only a US citizen can petition for married child. So, married child of a US citizen, that is the next one. And only a US citizen can do that. So, even if you are married, if your parent or parents are US citizen, they can submit a petition on your behalf, although it will take time because For all these categories, with the exception of immediate family of a US citizen, there are numerical limits. There is a limit to the number of green cards that immigration can approve annually. This is an act of Congress. Immigration does not have discretion over this. Nobody can change it except the Congress change the law. So, FB3, married child of a US citizen, they can submit a petition for you and then wait until whenever they get to your turn on the queue. The last but not the least, FB4, that is family-based category 4, US citizen petitioning for siblings. Again, only US citizen can do that. Permanent resident cannot do that. So, US citizen can also petition for siblings. However, the waiting period will be long because there are numerical limits to the number of green cards that can be approved for all of these categories, with the exception of immediate family of a US citizen. Are there questions here? Okay. I don't know. I think I don't know. I think I don't know what happened. So, if you have questions, send in your questions. While waiting for question, as I said, for all of these categories, okay, thank you. For all of these categories, family-based, category 1, unmarried child under 21 of a US citizen, family-based category 2, immediate family and unmarried child under 21 of a permanent resident, or unmarried child of a permanent resident over 21, or FB3, married child of a US citizen, and FB4, siblings of a US citizen. All of these 4 categories, they have numerical limits. There is a limit to the number of green cards that immigration can approve annually. The only exception to the numerical limit is immediate family of a US citizen. Immediate family of a US citizen. And as I explained, immediate family of a US citizen does not include your own biological child who is over 21. It does not include your grandparents. It does not include married children. So even if you have a child who is under 21 and you are a US citizen, but that child is married, it does not constitute a member of your family. So you cannot file a petition under immediate family of a US citizen, because as long as that child gets married, the child is no longer a part of your immediate family. So, very important to understand all these little distinctions. Now, there's a lot of questions that we always receive. A US citizen petition for a child, and then that petition has been pending for several years. So they are wondering, what is going on with my petition? Oh, I filed this petition 5 years ago. I've not had anything. I've not done anything. What you need to understand is that for as long as the category of that petition falls into extended family member, for as long as that child is over 21 or older, and it is extended family member, you have to go through the numerical limit. You have to wait for visa to be available. You have to wait for that child, for your petition to be current. That means they have to get to your turn on the queue before they can process your application. And sometimes this waiting period could range from 3 years up to 16 years. It could range from anywhere between 3 years and 16 years. For example, the last time I checked, siblings petition, the waiting period for siblings right now is about 16 years. The waiting period for siblings. So if you have a sibling who submitted a petition on your behalf in the last 10 years, I tell you, you still need to exercise a lot of patience because they are not even close. The waiting period is about 16 years right now. Okay, I see that questions are coming in. The first question. Hello, sir. My husband petitioned for me, but I only received a 2-year green card. What does this mean, and why is it only 2 years? Well, that is easy. You got 2 years because on the date that your petition was approved, on the date that your green card was approved, your marriage was less than 2 years. So because your marriage was less than 2 years, the law is looking at your marriage with suspicion. They are not sure if this is a real marriage or if this is a marriage just to get green card. So that is why they said, you know what, let them give you a 2-year green card. In 2 years, you come back and show evidence that your marriage is actually a real one. So all you need to do is just to apply for an extension or removal of condition in 2 years' time to prove to them that your marriage is legit. But let me say this, these 2 years does not negatively impact your ability to become a US citizen. If you remain married to your husband, even from the date of that 2-year green card, you start counting your eligibility for citizenship. In other words, you are required to be a permanent resident for 3 years if you are married to a US citizen in order to be eligible for citizenship. So these 2 years count towards that. So technically, you don't have anything to lose. You don't have anything to lose. But immigration just want to be sure that your marriage is a legitimate one and not one entered into for the purpose of evading immigration laws. So the next question. Question received via text message. What happens if I get a 2-year green card but my marriage didn't work? What happens then? Oh, okay. Okay. The next question. Question received via text message. Can I petition for my unmarried child if my removal of condition is still pending? Well, conditional green card and regular green card is not the same. So if your marriage is legit, your husband can petition for your child as a stepchild for as long as that marriage was entered into while your child was under 18 years. If your child is already 18, then there is no stepchild relationship. But if your child was under 18 at the time of marriage, not at the time of your green card, but at the time of marriage, if your child was under 18, then your child could petition for your child. But as for you, you cannot use the conditional green card to petition for your child because, as the name suggests, it's still a condition. So it's not a full-fledged green card yet. You still have the condition to remove, but your spouse can actually petition for your child if the marriage occurred before your child turned 18 years old. Question received via text message. I was told that if I have overstayed, my permanent resident husband can petition for me, but I cannot get the green card. Why is this? Oh, yes. If you are physically present here in the US, one of the major differences between a US citizen and a permanent resident is that a US citizen can petition for a family member, whether that family member is maintaining legal status or not. All that is required on the part of the family member is to show that you enter the US legally. Once you enter the US legally, it doesn't matter how long. In fact, recently, I filed a petition on behalf of a client. That client is a US citizen. The spouse has been living in the United States since 1982. Since 1982. And we are still able to file because it is the legal entry at the time that matters, not whether you are in status or not. But on the other hand, this does not extend to permanent resident. Permanent resident does not have the same benefit. So if a permanent resident is going to petition for you, yes, the petition will be approved, but you cannot apply for green card. For you to get a green card through marriage to a permanent resident, you must be maintaining legal status at all times. From the date you enter the US up to the date you apply for green card, you must show evidence, documentary evidence that you have been maintaining legal status. However, there are very, very limited exceptions. There is something called adjustment of status under section 245I. Very limited exception, but generally you cannot get green card if your spouse is a permanent resident and you are already out of status. If you need additional information about this, I will suggest that you go and watch our podcast on INA 245I. Applying for adjustment under 245I. There is a podcast that I did on that topic. But for this purpose, generally, you cannot get green card if you are out of status and your petitioner is a green card holder. Only a US citizen can do that. The next question. Question received via text message. Excuse me. What happens if I got a 2-year green card but my marriage didn't work? What happened then? Well, the law does not require that a marriage must work. The Congress is well aware that marriages do fall apart. Things happen in a marriage. Even marriages between two US citizens, they do have their challenges all over the world. That is not peculiar to any country or anybody. However, what the law requires is that you must enter into that marriage in good faith. That marriage must not be solely just for you to get green card. So, if your marriage fails while you still have your green card, you may still be able to remove the condition. What you will need to prove is that this marriage was entered into in good faith. Now, how do you do that? Definitely, your marriage cannot fall apart the same day you got your 2-year green card. You still have to show what happened between the date you got the green card and the date your marriage fell apart. So you have to show evidence of good faith, evidence of relationship. What did you two do together? Evidence of commingling of assets after the 2 years, not before the 2 years. Remember, once you get the conditional green card, the 2-year green card, whatever evidence you have before that green card was approved will no longer be relevant. It is what you did from the moment you get the green card that matters. So, if you got your 2-year green card and then you suddenly realize that you are not compatible with your spouse and then you left the marriage, that will be problematic because you are going to face a Herculean task of convincing immigration that you did not obtain the green card solely, you did not get into the marriage solely for the purpose of the green card. But if legitimately, maybe 2 years, maybe even 1 year after the marriage, you have a legitimate misunderstanding. Because when you apply for a removal of condition based on good faith marriage, immigration is not going to approve it without interview. There is a 90% chance that you are going to be interviewed. And when they interview you, they are going to ask you what led to the problem in the marriage, what actually happened, and then they are going to assess the situation and conclude whether this was a marriage for immigration purpose or a good faith marriage that just didn't work. But the fact that your marriage didn't work is not by itself a guarantee that your conditional removal of conditional application will be denied. No, you still have the opportunity to show that your marriage was entered into in good faith. The next question: how do I begin the green card process for my husband who is currently outside the US? Well, this is a consultation issue. This is not a podcast issue. I mean, if you want to consult, you can call us, or you can also consult with other immigration attorney. But generally, a US citizen, you file a petition on behalf of your spouse. If your spouse is here, you can apply for green card concurrently with the petition. But if your spouse is outside the US, then you file only the petition and wait for the petition to be approved. Upon the approval of the petition, they will send the approval to the National Visa Center. So the National Visa Center will process it. That is where you will be required to submit immigrant visa application, affidavit of support, and all of those things. Then you will also submit, your spouse will submit police clearance to show that there is no criminal ground of inadmissibility. Once the National Visa Center finish processing, they will forward the file to the US Embassy in your home country or where your husband or your spouse is. Then once you get that, once they forward it, they will send they will provide information of where your spouse will conduct medical examination. So upon medical examination, your spouse will go for interview. Once interview has been scheduled at the US Embassy, and if everything goes well, an immigrant visa will be issued for your spouse. And then after the immigrant visa is issued, then you will need to pay green card processing fee. And then from that moment, your spouse can come to the US and join you here. That is the process for somebody who is outside the US. But for people who are inside the US, they can file all these applications together at the same time. The next question: I married my wife while my employment-based permanent residency petition was pending. Do I have to file a petition before she can come to the United States to join me? I'm not sure I understand this question. I married my wife while my employment-based permanent residence petition was pending. We are not discussing employment-based today. We are discussing family-based.
But we're talking about, so the green card was approved based on that. He's asking, does he need to file a separate petition for his wife to now get her green card? Like, she's not in the country, and he wants her to get
To join her here. Well, like I said, the question is not very clear, but using the explanation given here, if your question was that you got your own green card through employment, your spouse is outside the US, and you want your spouse to come and join you here, what do you do? Well, it depends on a number of factors. Number one, at the time you are applying for your employment-based green card, were you married at the time? If you are married at the time and in your application, your marital status was disclosed, then all you need to do is to follow a process known as follow to join. So you file Form I-824, follow to join. So upon approval, they will send it to National Visa Center and your family will be able to join you. On the other hand, if you are not married at the time the petition, your employment-based petition was filed, then when you get your green card, you now have to file a petition on behalf of your wife. And of course, because your wife is outside the US, the issue of legal status will not come up at all. So just file the I-130 petition, wait for the approval. Upon approval, they will send it to National Visa Center. There you submit affidavit of support, immigrant visa fee, and then immigrant visa application. After that, wait for the National Visa Center to schedule an appointment for you at the US Embassy in your home country. Once that is done, then your wife will do medical examination and then attend an interview. So once the immigrant visa is issued, your wife will now pay, or you can pay, the immigrant green card processing fee. That is the process. But if you are married, before you apply for your employment-based green card and that marriage was disclosed in your application, then you don't need to file a family-based petition. Rather, you need a process known as follow to join. The next question: can I skip the removal of condition stage if I apply for naturalization? No, you cannot. It's a requirement of the law. If you skip it, your application for naturalization will be denied, and it is likely, very, very likely, in fact, 98% chance that you'll be placed in removal proceedings. You'll be placed in removal proceedings. You cannot skip it. It doesn't matter who your wife or your husband is, even if you are married to a US citizen, even if you are married to the US president, you still have to comply with the law, because that is the law. Except the Congress change it, you cannot skip that process. The next question: my 20-year-old son would like a green card and I'm a US citizen. If my son turns 21 after I file the petition for him, will he have to wait until a visa becomes available? Well, if you are already a US citizen at the time you file the petition and your child is 20-year-old, the waiting period will not affect your child, even if your child turns 21. There is something called Child Status Protection Act. So for as long as at the time you filed the petition, visa was available, and in this case, if you are a US citizen and your child is 20-year-old, that qualifies your child as an immediate family member of a US citizen. So that means visa is automatically available. So once you meet that requirement and you file your petition before your child turns 21, then Child Status Protection Act will kick in and your child will still be able to get the immigrant visa even after turning 21 without switching the category to unmarried child of a US citizen over 21. The next question received via text message: what can happen if I file for my removal of condition after expiration of my temporary green card? Well, if you file after expiration of your temporary green card, USCIS will still process it. However, whether they will approve it or not will depend on your explanation, because for as long as you fail to file before the expiration of the 2 years, you will need to explain why you did not file on time. So if your explanation is acceptable, they will still approve it. But if your explanation is not acceptable, They will still accept the application and process it, but it may be denied. But you still have to apply and explain why you did not apply on time, that is, before the expiration of the green card, of the 2-year green card. The next question, received via text message. So just to confirm, once my husband becomes a US citizen, then I can apply for green card, right? Oh, yes. If you, well, I don't know if this person is inside or outside, but in whichever way, yes, you can apply. However, if you are inside, you have to show legal entry. You have to show that you entered the US legally. That is it. If you are outside the country, that is not even an issue. But yes, once your husband becomes a US citizen, you become immediate family of a US citizen, and you can apply. Your husband can file a petition on your behalf. The next question. I'm a permanent resident and my wife has a daughter from a previous marriage. Can I sponsor my stepdaughter for a green card? Yes, for as long as your marriage to your wife happened before your stepdaughter turned 18 years old. Yes, you can file a petition on behalf of your daughter. If your daughter is physically present in the US, in order to apply for green card, you have to show that she has been maintaining legal status. But that does not affect the petition. The petition only requires you to prove your relationship with your stepchild. But yes, you can do that. The next question, received via text message. I was physically abused by my US citizen husband. I got my temporary green card, but we are no longer together. I've been told I need to apply for VAWA. No, this is okay. I need to apply for VAWA instead of removal of condition. What is the best route? Whoever gave you this advice is ignorant. You are not even eligible for VAWA. You cannot apply for VAWA. If you already have a conditional green card, that is 2-year green card, if your marriage fails and you are abused by your spouse, you go ahead and apply for removal of condition and then show the evidence of abuse. So that will constitute evidence of good faith marriage, and then you still be able to get your green card. Your condition on your green card, you still be able to get it removed. But you can't go back to apply for VAWA because you are still a conditional permanent resident. So your best bet, when it is 2 years time, apply to remove condition and provide evidence of the abuse from your relationship to your spouse. The next question. My wife filed a petition for me, but it was denied. In the denial letter, USCIS said that it was because of a marriage fraud determination. If I get divorced, can my new spouse file for me? Well, your new spouse can file for you, but that does not overcome the allegation of marriage fraud. I've stated on this podcast multiple times that Section 204C of the immigration law makes the approval of a family-based petition impossible if immigration makes a determination that an alien has entered into a marriage for the sole purpose of evading immigration law, or an alien has conspired or attempted to enter into a marriage for the purpose of evading immigration law. So no subsequent marriage can overcome that challenge. You still have to go back to address that issue of marriage fraud. So if you have evidence that your marriage was not fraud, you need to appeal the decision, or you need to refile and provide the evidence if you have lost the chance of appeal. But going to marry somebody else does not solve that problem. It's just pushing the problem forward, and you are still going to meet it in front. So you have to address it. Is either your marriage is either you enter into a fraudulent marriage or you didn't enter into it. There is no way around it. Getting married to somebody else does not solve that problem. The next question: Can US citizens sponsor half siblings or step siblings for a green card? Yes, if you have the relationship. Sibling is siblings, whether it is your relationship is based on one parent, whether your mother or your father. For as long as the person is your sibling, yes, you can petition for a step sibling or half brother or sister. But the most important thing is to show the relationship. That is the eligibility requirement. The next question, received via text message: I'm a US citizen. Can I file for my niece? No. Apparently, this person just joined us. I define US citizen being a family of a US citizen. I define it at the beginning of this podcast, and I'm going to repeat it. For immigration purpose, family is not defined the same way English dictionary defines family. So for immigration purpose, family of a US citizen is limited to parents, spouses, that is husband or wife, and children under 21. That is the definition of family for immigration purpose. So your own biological child who is 21 and above is not part of your family for the purpose of US immigration law. Now, apart from family, then the next one is extended family. Again, extended family for immigration purpose includes your children who are over 21, whether married or unmarried. It includes your siblings, and of course, it includes your parents, your spouses, and your children under 21. It does not include grandparents. It does not include cousins. It does not include nieces. It does not include nephews. So, a US citizen cannot petition for nephews. A US citizen cannot petition for nieces. A US citizen cannot petition for cousins. A US citizen cannot petition for grandparents. All those ones does not form part of the definition of family for immigration purpose. The next question. My spouse was a US citizen. He filed Form I-130 and it was approved. My I-485 was pending because they needed my medical exam. During this time, my spouse died. Can I still get my green card? Yes, you can get your green card. All you need to do is to respond to the request for evidence, the medical examinations they are asking for. Send it to them with a letter explaining that your husband is now dead. Attach a copy of the death certificate and request that they treat your petition as a widower petition. Yes, your green card will still be approved, but you will be treated as a widower of a US citizen. The next question. received via text message. I like to adopt a child abroad. After the adoption process is granted, can I get citizenship for her? Well, this person didn't say if he or she is a US citizen, but let's assume that you are a US citizen. There are two ways to get adoption. It depends on the country where you come from, where you are applying from. It depends on whether that country is a member of what is known as the Hague countries. So if it's a member of Hague countries and you follow the adoption law as set up by the Hague Convention, yes, that child will come to the US, will enter the US as a citizen. You will not need to file any petition at all. That child will enter the US as a US citizen. However, if you follow the traditional path, or if you are from a country, the adoption is coming from a country that is not a member of the Hague Convention, then that means that after the adoption, you need to file Form I-130, petition for alien relative, on behalf of this child, and wait for that petition to be approved. Upon approval, they will forward it to the National Visa Center. You submit immigrant visa application on behalf of that child, affidavit of support and the fees. You depending on the age of the child, you submit immigrant visa application and police clearance, and then follow the normal process of petitioning for your own child. That is the difference. But if it is the Hague Convention, you will not need to go through that process. Once you finish that adoption and that child comes to the US, that child will enter the US as a US citizen in the case of Hague Convention. The next question. If my sibling comes to the US, if I petition for him here, will he have legal status? No, it does not. I've repeated it multiple times during this podcast that siblings do not form part of immediate family. Because they are not part of immediate family, they cannot even apply for green card based on your sibling petition. The only thing your petition does is that it puts your sibling on the queue. The date you file the petition, that is the date that he joins the queue, and then you wait. And currently, like I said, waiting period for siblings is about 15 to 16 years for siblings, depending on the country where you come from. In some cases, it could be up to 20 years. I mean, if you are from a country like Mexico, for example, the last time I checked, they were still processing cases that were submitted in 1999. If you look at 1999 to today, that is about 25 years of waiting. So it depends on the country. But if you are from Africa, currently is about 15 years. So all your petition does is to put him on the queue. That is it, nothing more than that. So because he cannot even apply for green card, your petition does not keep him in status. So if he's going to be in status, he needs to find other means of keeping himself in status. Your petition cannot do that.
Mexico, they're doing February 2001.
Oh, they have moved.
Yeah.
Okay, I was just told that for people from Mexico, they are now in February 2001. So that will take it to about 24 years of waiting.
And all other countries, other than the ones listed, it's August 1st of 2007.
So for Africa, August 1st, 2007, that is how many years now? That's about 16 years. Yeah, I was right. That's about 16 years. So it's about 16 years of waiting if you are from Africa, and it's about 24 years of waiting if you are from Mexico. So the next question. My husband filed for me. I read online that USCIS no longer called anyone for interview, but we were called for an interview. What does this mean? Well, I don't know where you read that online, but whoever posted online was misleading you because that is not true. USCIS still call people for interview, so your case is not different. There are situations where petitions can be approved before without interview. That does not mean that USCIS stop calling people for interview, but straightforward cases that do not require any question, yes, sometimes they can be approved without interview. But again, even straightforward cases can still be invited for interview. I've seen a case that was extremely straightforward. These people, this client, they were married and they have 2 or 3 children. Everything about their everything about their marriage was straightforward, but they were still invited for the interview. Their case was so straightforward that even during the interview, I asked the officer, I thought this is one of the most straightforward cases. Why was this person still called for interview? And the officer reviewed it and said, well, he has no answer. That sometimes they do. So it is not it is not guaranteed that a particular person will be invited for interview or will not be invited for interview. Even USCIS themselves cannot tell you that a particular case will not be called for interview. That is not the way it is. The only thing is that cases that are straightforward, cases without red flag, cases that does not require additional question, cases that does not require any form of clarification, sometimes may be approved without interview. The next question. Question received via text message. Is there an age limit for adoption? Oh yes, you have to adopt a child. If you want to adopt a child, the adoption process must be completed before the child turns 16. The cutoff age is 16. Once a child turns 16, you can no longer, well, you can still adopt the child, but you can no longer file for that child for immigration purpose under the US immigration law. However, there is one exception to that rule. If you are adopting a sibling, 2 children who are siblings, and one of them is under 16, you may be able to adopt both of them together with the one that is over 16, but not more than 17. But the cutoff age for adoption is 16 years. The next question. I am currently in the USA on B1, B2 visa. What are my options of becoming a legal resident, please? Well, this is not for today's podcast. This person is taking us back. I will suggest that you go back and start listening to all these series. We started a series, and this is probably our 5th or 6th week on this series? I think it's about 6th series. This is our 6th week on this series. The series is titled How to Live and Work in the United States. So we started from the visa process, and we okay, this is our 5th. Okay, so we started from the visa process, how to prepare for visa, how to obtain a visa, coming to the US, admission process. Once you are now in the US, what are your options? We started discussing it, and I think we discussed employment based last week. We are discussing family based this week. So This question that this person asked is an open-ended question that I cannot finish answering in the next 3 or 4 hours. So go back to our podcast and start listening from the series, from the beginning of the series. The next question received via text message. Can I apply for work permit while waiting for my husband to become a US citizen if the I-130 has been approved? No, you cannot, because like I said, if you are out of status and your husband is not yet a US citizen, you cannot even submit application for adjustment. And employment authorization in the family-based petition is the basis, is attached to adjustment application. So if you cannot, if you cannot even submit adjustment application, it stands to reason that you cannot apply for employment authorization, because employment authorization is attached to adjustment application. And if you are out of status and your husband is not a US citizen, you cannot even submit adjustment application. So the answer is no, you cannot. You have to wait until your husband becomes a US citizen. From my own end, it seems that is the last question. Is there any other question that came in through any other phone? Can you please check?
No, like on text?
No.
Okay.
No, I checked.
Okay.
Okay, let me check.
Please check again before we round up. I know it's already 1 o'clock, but I don't want to miss any question that has been sent in.
No.
Okay. In the absence of any additional question, we'll be rounding up today. Is there anything we are still yet to discuss on this series? Coming to live and work in the US? Okay.
So, like,
Or even maybe we need to discuss visa bulletin. Okay. We are going to continue this series next week by God's grace. We still have 2 more topics on the series. We are still going to discuss humanitarian reliefs. We are still going to discuss visa bulletin. I think visa bulletin is a very, very important topic because we get questions on it every single day. Every single day. We get email questions, we get people call, we get people send messages asking about visa bulletin. That is something that a lot of people inside and outside the US does not understand. So next week, by God's grace, we will continue with this series, Coming to Live and Work in the US series. And next week, we'll be discussing visa bulletin. Please note that topic. Thank you again for joining us. Remember, the only thing you can do to show appreciation for all this information we are providing free of charge is to pass the information to others. Let others know about this podcast. Let others also benefit from it. Let others also join, because we are doing this to ensure that people avoid needless mistakes, needless errors. And even the Bible says that my people perish for lack of knowledge. Knowledge is very vital. We have seen people make avoidable errors, avoidable mistakes. We have seen people extend their journey from what ought to be 40 days, Israelite journeys, to 40 years. We don't want that to happen to you or to your family or to people you know. That is why we are contributing our own quota in ensuring that you get adequate information. As you can see from this podcast, several times people sending questions, citing things that they read online. There are a lot of misleading informations online. There are a lot of half truths online. There are a lot of things that are misleading that people post online. That is one of the reasons why we are doing this, to ensure that people get the right information, that people avoid those needless errors. So the only thing you can do to show appreciation, let others too benefit from it, so that at the end of the day, everybody will be happy. Okay, message. Thanks to you and your team member. It's truly appreciated. Thank you, thank you. That is very encouraging. So we hope to see you again next week. By God's grace, we'll be proceeding with the coming to live and work in the US series by God's grace. See you next week. God bless you. Remember to invite your family members, your friends, and your colleagues at work. 12 p.m. Central Standard Time, 10 p.m. Pacific, 1 p.m. Eastern, currently 6 p.m. Nigerian. God bless you. See you next week.